Welcome. Today we will be discussing certain HR related issues that are commonly brought up within the workplace that can ultimately lead to litigation. And the design of this presentation will be sort of a highlight of those issues that often come up and how to deal with them. The details of the law on each type of claim or each type of problem has been addressed in other webinars. So this webinar sort of builds upon others, but nonetheless, if you're just joining us for the first time, I think you'll be able to still get some information from it. So here's an overview of what we'll be discussing. First, when the employer is responsible for employees' conduct and omission. Obviously, most of the claims that arise come from an actor, an employee, not the actual entity, the LLC or corporation itself doing something to the employees. You know, it's some other person within the company doing something that they should not be doing or not doing something they should be doing. So we'll address that and then move to documentation, the importance of it. Again, you'll never hear the end of that. And then we'll summarize, or we'll end with an overview of some common employment claims against companies, including Title VII discrimination claims, hostile work environment claim, retaliation claim, and sexual harassment. So let's begin with when is the employer responsible for an employee's conduct? There are generally three situations where the employer may become responsible. First, we will think about the normal operating hours, the normal work hours of the day in which people are working or they're on our premises. So when the alleged harassing employee acted within the course and scope of his employment in furtherance of the employer's business. This can be pretty broad, but generally speaking, during working hours or on company property, in furtherance of company business, which it's presumed to be in furtherance of the business if it's on company property during company time. So there is one situation which an employer may become responsible for employees' conduct. Another is where the employer failed to address the complaints filed by an aggrieved employee against the alleged harassing employee's conduct. So this is where the employer either takes like a blind eye or a deaf ear approach, or perhaps the employer just really is not aware. And by employer, I mean, management. Management, the employer may not even be aware of it, but perhaps could still be liable because there is a duty to ensure a safe and healthy work environment. And then the last situation where the alleged harassing employee held an important position in the employer's business so that his or her actions may be attributable to the employer. So here we just think of an easy example of a supervisor or a manager or some other person in management or a supervisory capacity. Now, it's important to remember that a company can be liable for the acts, of course, but also the omissions. And the omission is a failure to do something when there was a legal obligation to act. So you'll kind of see this piece together of when managers and supervisors and upper management HR people should be acting. One of those situations is where they see something or hear something that's not right. They have a responsibility to act. They cannot take a blind eye. And we'll kind of touch on that throughout this presentation. So let's move to a quick point on documentation. There's a Chinese proverb that says the palest of ink is better than the best memory. And so I think it's important to remember that a page of documentation that kind of accurately represents a situation in real time is often greater than 5,000 words of testimony later on when a company is trying to defend itself in court. So not to completely delegitimize, verbal testimony, but when we have documentation as to what was going on in real time, that certainly gives us quite a bit of evidence as to the evolution of events, because we can all make up things later on, and we also know that our memory has some difficulties associated with it and that it's sometimes not always accurate. So that's why documentation is important. It really serves as more of an accurate recollection of facts versus perceptions. Now let's move on to how a discrimination claim is litigated. Title VII prohibits discrimination, we know, based on protected classes. And so a plaintiff, your employee or previous employee, or applicant, or some other person situated with the company, a plaintiff can establish a prima facie case based on circumstantial evidence by showing, one, that he or she is a member of a protected class. So there's various protected classes, but under Title VII, I've listed race, color, religion, sex, and national origin. Two, that the person was qualified for the position and performing the job satisfactorily. So obviously this is an employee, not an applicant, but an employee that has alleged either race, color, religion, sex, or national origin discrimination. They're of a protected class, and they were qualified for this position. They were performing the job fine. Third, they experienced some adverse employment action. Adverse employment action does not have to just be a termination. It could be denial of certain benefits or promotions, or a demotion or suspension, and so on. And then lastly, that similarly situated individuals outside that protected class were treated more favorably. Or we could show that some other circumstance surrounding the adverse employment action, like the termination or demotion or denial for a promotion or whatever, gives rise to just an inference generally of discrimination. So you can see it's pretty easy to establish a claim of discrimination. And so that's why we want to really be aware of things that kind of get pieced together along the way, because pretty soon a couple, bad acts on behalf of one of our employees can turn into something bigger later on. We'll see that played out through a hypothetical I put towards you to sort of find a conclusion on your own too later on. But we want to be aware that the claim is actually quite easy to establish, and so it's important to be proactive with recognizing certain issues early on. I will note that just because you establish this does not mean that you've won your case, that the plaintiff won its case. There's other sorts of legal analyses that have to take place, but this at least gets the plaintiff to the door, I'll say, gets them to court. So we'll start with a hostile work environment and harassment. Harassment is a form of employment discrimination that violates Title VII, the Age Discrimination and Employment Act, and the Americans with Disabilities Act. It's unwelcome conduct that's based on race, color, religion, sex, national origin, older age, beginning at age 40, disability, or genetic information. First, unlawful harassing conduct must be unwelcome and based on the victim's protected status. So we have issues where a person, it usually arises where a person is seemingly fine with certain types of conduct with another employee, but then later on, maybe because they don't like that employee anymore or whatever, they're no longer fine with certain conduct. And they're now alleging that this type of conduct was directed at them because of their protected status. And there are, of course, other situations in which people just say, hey, since I got here, I've basically been enduring harassing conduct from my supervisor or coworker or whatever. But it generally seems what comes to me is instances where people are kind of fine with a certain type of behavior until they're not fine with it. So first we have that. Second, the conduct must be subjectively abusive to the person affected and objectively severe and pervasive. So let's first hit on that first point. Subjectively abusive, that's just always established, right? Because it's your personal opinion of whether you're being offended or abused by someone. So that's just kind of check, they've got that. Now the second one's a little bit more of a inquiry and a fact-based inquiry here. We have objectively severe and pervasive enough to create a work environment that a reasonable person would find hostile or abusive. So this isn't whether the alleged victim finds it to be a hostile work environment or they find it to be abusive. but it's whether a reasonable person would. So whether an instance or a pattern of harassing conduct is severe or pervasive, we determined that based on a case-by-case basis with consideration of the following factors, which I won't read. And then we move on to that point of that reasonable person standard of whether they would think that severe and pervasive conduct is abusive. Each factor considered, is important, but no one in particular is dispositive of whether a person would have a claim. So again, we see a lot of claims where plaintiffs are piecemealing things together, right? Like no one instance would have given them a legitimate claim against their employer for a hostile work environment or harassment, but when they piece together 6 different points of conduct over a period of a year, we might be looking at a different issue. Now, also what an employee is protected under the law, not just to be free from discrimination, but also to be free from retaliation. So just a reminder, it's prohibited to punish job applicants or employees for asserting their rights to be free from employment discrimination, including harassment. I think that's, obvious, like none of us are really targeting people because they, filed a formal complaint with us internally, or because they're alleging their supervisor did something wrong or their coworker did something wrong. It's generally, in my opinion, not the employer actually targeting a retaliation against them. The employer, as in like maybe the president of the company or the HR director, but it sometimes is the employer in the form of the supervisor, right? Because if the employee's complaining about their supervisor, the supervisor obviously then gets questioned about it from HR. And then sometimes that supervisor will, put them on the less desirable shifts or in some other way sort of subliminally retaliate against them. And that's sort of where we see that come up. Let's go through a little example here. This is actually taken from a real case, but the plaintiff in this case was a former employee of a company and he was Cameroonian and Black. That's important, of course, because we're looking at whether there was a protected class based harassment, discrimination, retaliation. And in this case, he stated that he was both discriminated against and retaliated against because of his national origin, race, and color. So the plaintiff was terminated from his position with the company. I changed the dates to align with this year, but we'll say on the July 11th of this year. And on September 2nd, that took place exactly on those dates, but on a different year. He filed a charge of discrimination with the respective state Human Rights Commission and the EEOC. He alleged that his termination was based on race and national origin discrimination. And then he also alleged that he was retaliated against by the company because he was not rehired for positions that he applied for after his termination with the company. So what happened is he was employed, he was terminated, and then he, like a month later after he was terminated, applied for all these open positions. I think there are actually several of them, and he just started applying for them. And of course, he didn't get interviewed, and he was just, because he was just terminated, and HR basically just like disregards his application. And he's saying he was retaliated in the form of not even being interviewed, not being hired for these positions he applied for. And it was because, relating back to this discrimination claim. That example is to just illustrate how a seemingly simple conversation, excuse me, I might be missing a slide here, but let me explain a little bit more about this case. Where the whole allegation came up about, his termination relating to race and national origin, it was about 2 discriminatory incidents during his tenure. The first one occurred at the company's Christmas party event the previous year. And at that event, a salesperson employed by the company just kind of asked questions to the plaintiff about his nationality and asked him some American citizenship test questions, including questions like about the Civil War and former American presidents. And the salesperson kind of just gave him some of these quiz type questions in front of other employees. And actually, I think there was one documented executive that was actually listening to this. The interaction only lasted like 3 minutes. But then on a subsequent occasion, the plaintiff spoke with this same salesperson for several minutes with this other employee. And the salesperson then asked him questions about his nationality again, and then about how to get a green card. So, to some that's inappropriate, to others it's just, perhaps the salesperson just having a legitimate conversation with the guy. It can be taken either way, but really the point of this is that it's something as simple as that can perhaps get the EEOC involved. The EEOC sort of liberally gives these letters of rights to sue, and then the person can go sue their company. I hesitate in telling you the outcome of the case because I don't want you to think that the facts, the limited facts I gave you would always lead to this type of decision. But the plaintiff did not end up winning in this case, and we don't have the time today to explain all of the reasons why. But it's important, the takeaway from this, it's important to realize that such, sort of a simple one or two conversations touching on certain protected categories got this company sued. The fact that they ended up winning is sort of neither here or there for the purpose of this discussion. It's really to just illustrate how simple conversations can be and lead to issues later on for an employer. Now, on the following slides, I've provided a sample checklist for preventing and responding to internal retaliation complaints. It's really designed to assist in HR management, in the process of receiving and responding to internal complaints by current employees, to thus avoid potential retaliation claims. So I'm going to briefly go over that, and if you want the list, I can email it to you. Just reach out to me via email. It may also be listed on the TPM website. I don't recall, but I can always email it to you. And it might even be, you might even have some form of this sort of in your own internal workings, but I think nonetheless, it's good to just give an overview. And I'm not going to read each individual bullet point here, but first we create a formal complaint procedure. So we should A, have a complaint form for employees, and B, we should have some sort of complaint procedure. And it can be simple, but we should have something. And likely you have that in your employee handbook, something referencing, hey, if you're feel like you're being discriminated against or harassed, here's our complaint procedure, and we also have a complaint form. Then we want to have a sort of plan as to how we're going to investigate the complaint. We designate a neutral investigator. Usually it's our HR director. If we don't have one, it's often like our office manager, or some other person, office personnel that has sort of oversight of company activities. And then we draft an interview plan identifying all potential witnesses with relevant information. So we have the person complaining about someone else, and then we need to look to potential witnesses to kind of corroborate this, or to find that it's not truthful. So we kind of start making our list of people that we want to interview. Investigating the complaint, it's multifaceted. We want to promptly contact the complainant, the person that's alleging something is wrong, to schedule an interview with them and also get, like a written statement from them. Again, goes back to that in real-time documentation that we want. We don't want to just, a year and a half later when we're defending ourselves in court, say, well, the, complainant said this and that. I mean, we just need to be able to provide what they allege. And then we determine whether any immediate action is necessary. So if they're saying, my supervisor is like groping me, then immediate action is necessary where that person's not reporting to work the next day under the supervisory authority of that manager, supervisor. Or if it's even a coworker, that person is not reporting to work in the same environment of that coworker. Perhaps the alleged wrongdoer needs to be given, maybe a paid leave of absence for even a day, right? Just to be sent home for us to figure out what we're going to do and to investigate the complaint. And then we go into interviewing the complainant, which is, the person alleging something's wrong. We go into interviewing witnesses, and then we collect and review documents that might be relevant to the complaint. And that leads us to drafting the investigation report. This is important because the reason for this whole list of things that we're doing is because part of our responsibility as an employer is to show the court, ultimately, if we have to, that we did what we had to do, that we did not have omission, right? A failure to do something that we had an obligation to do in investigating and taking correct action based on the complaint. So we're documenting the alleged problem and the alleged conclusions that come from this problem and investigation. But it's also more than that. We're actually doing all this documentation, this process for ourselves. We're protecting the company because we have a duty to do it. So we are also retaining this to show that we did what we had to do, that we took it seriously, and that we went through all of the steps. So that's where the investigation report comes in, where you're kind of summarizing basically who you interviewed and why, and what you found out, and then ultimately why you're deciding what you're deciding, which goes into concluding the investigation. Now let's move on to sexual harassment. Supervisors, managers, executives, they're all responsible for appropriately handling sexually inappropriate behavior within the workplace environment. So let's first talk about what sexual harassment is. I think I have like a whole webinar on this that goes into detail, but we'll just do a quick refresher. It's harassment of a sexual nature. So this can take the form of either quid pro quo, which is this for that, which is basically, somebody's requesting sexual acts in return for favoritism employment. Pretty broad as to how that can be interpreted. Or it's a hostile work environment issue, which occurs where behavior creates a hostile, intimidating, or offensive work environment. It's unwelcome conduct, and it consists, as we previously outlined in a couple slides ago, of severe and pervasive conduct, and it's an unreasonable interference with an individual's job performance. Here's a sort of a little graph that we can remember. Sexual harassment is not just something physical, right? It can be visual, simply like allegations of someone within a workplace staring in certain areas and for extended periods, or posters or like pictures on their phone that they're showing their coworker, etc. So visual is one category. We have verbal, so that's more obvious, and then we have written, and these are sometimes like text messages, I'd say, in more modern terms, or we have like issues that arise where, say, a coworker is getting like Instagram or Facebook messages or text messages from their coworker, maybe even outside of working hours, right? But it's like of obscene things or of sexual content or references. So those are all things, whether it's visual, verbal, written, really kind of in any form or any time, those are all things that we will ultimately have to review. Now, that's not that it will always be this alleged wrongdoer, the person that's sending the text messages or doing all this. It's not that that person's always going to get fired. It just means that we're going to have to investigate, and then we're going to have to determine what, if anything, is going to happen. Sometimes nothing, because we investigate and we realize it's not meeting the criteria for really anything that would qualify as sexual harassment. It's really more of a personality conflict, or oftentimes we learn that there's sort of this relationship, or if you could call it that, this interaction happening between colleagues, and then one of the colleagues gets back with their other husband or wife or boyfriend or girlfriend or whatever, and no longer wants that type of interaction with their coworker, and now they're not okay with the things that are being presented to them by that coworker. So we have to work through the investigation to really determine the legitimacy of the complaints and whether we need to have corrective action for anyone. We want to be prompt, though. Of course, we want to be thorough, and we want to show impartiality. So even if we know the answer and we know what's been going on, and it's really not, in our viewpoint, a big deal, or the complainant's, misconstruing things, we really have to show impartiality throughout, and throughout our documentation notes and throughout the process of interviewing. We were interviewing the employee who complained. We're interviewing the alleged harasser, and we're interviewing witnesses, anyone that could be expected to have relevant information. And before completing the investigation, the employer should take steps to make sure that the harassment does not continue. So that's if we've determined there is harassment, now we're going to determine what we need to do to ensure that it does not happen again. Sometimes that leads to a termination of the harasser. Sometimes it leads to other alternatives, of which I won't detail now, but we do have options, and we need to explore those options if we determine that there is in fact harassment. One question here before we kind of lead to our summary and conclusion. Is a complaint procedure adequate if employees are instructed to report harassment to their immediate supervisors? The answer is yes, but it's conditioned on something. Yes, so long as there's an option to report harassment to someone else too, like HR. You know, if the supervisor is the alleged harasser, you know, then obviously our complaint procedure of requiring complaints to go through the supervisor is not going to be an adequate remedy. So when we're telling the EEOC or the court, hey, we had a complaint procedure and the, you know, our employee just didn't even use it, and so how could we be liable? You know, our complaint procedure says you had to go through your supervisor only, and the supervisor is the person that's alleged to be the harasser, then that's not a legitimate avenue for the alleged victim. So something to be careful of. And I think most of your policies would say, you know, supervisor, and that gives an option, or HR, or whoever else. And some altogether skip the supervisor and go directly to HR. But again, we'd want to have another option where it's not just, you know, then the president of the company or just HR director, because what if it's alleged the HR director or the president is the one that is doing the harassing? So we would, this simply put, we want to have probably two options available for people to submit their complaints. And by options, I mean people, departments. So in summary and in conclusion, we discussed discrimination claims, hostile work environment claims, retaliation claims, and sexual harassment, which are the glaring ones within the workplace. The need for documentation is important. And when needed, reach out to TPM. Thanks for joining. We'll see you next time.